my speaker is very loud, because if otherwise there's an echo. So that could be.
Yeah, I just wanted to say something.
Yeah. You can hear.
Yeah.
There we are. Why am I not? How do we get rid of this pain here? Take note. Testing 1, 2, 3.
I can hear you again, Judge.
Very well, thank you. We are almost ready to start. Good. Ready to start?
The public protector was the Speaker of the National Assembly and others.
Thank you, everybody. Let's see if everybody is with us. Mr. Mpofu, you are with us.
Yes, yes, I am. Good afternoon, everyone.
Good. Mr. Breitenbach.
Yes, my lord. Good afternoon, everyone.
Thank you. Mr. Budlander. And Ms. Pillay.
Yes, my lord.
Mr. Budlander is muted. Hello.
Very well. Mr. Mpofu, have you and your colleagues worked out the division of time over the next 2 hours?
No, no, my lord.
So, how long do you anticipate to be, Mr. Mpofu?
Well, I was thinking more like maybe for 45 minutes and then maybe 15 to 20 minutes in reply. Let's say, yeah, it's 120 minutes, so that should work. Yeah.
Mr. Breitenbach, how long would you need?
Lord, I'll be brief. I have heads and my learned friend has given us notes and I'll speak to his notes.
Very well, thank you. Mr. Budlander. We can't hear you, Mr. Butlander. You're on mute. Mr. Butlander is on mute. Ms. Play, can you hear us?
Yes, my lord, I can.
Good. How long will you need?
My lord, I don't anticipate longer than about five to 7 minutes max.
Very good. Thank you.
Thank you.
Has Mr. Butlander joined us again? Mr. Tofi, are you? Yes. Who's Ms. Blizzard? Are you with us?
Lord, Mr. Butlander is waiting in the lobby.
I've admitted all in the lobby.
Hi. Hello, my lord. Can your lordship hear me now?
Yes, we can hear you.
I'm terribly sorry. It wasn't in fact mute. It was a problem with Teams, and I couldn't turn the mute off. I do apologize. I was saying I'll be brief. I certainly don't think I'll be more than 15 minutes at most, my lord.
Very well. Good. Very well, Mr. Poff. Well, good afternoon to everybody for your attendance. This then is the application for leave to appeal. We've received the heads of argument from all the parties. We've also received a note from Mr. Mpofu. You can take it that we've read it. We're sitting in my chambers. Judge Steyn is here and Judge Samela. Thank you, Mr. Mpofu. You're on the floor.
Thank you, my lord. And my lords and my lady, and good afternoon, colleagues. Lord, yes, we apologize for the lateness of the note, but it was an effort to try and succinctly condense the argument. So we will follow the sequence in the note, obviously subject to your lordship's interruptions and questions. So just maybe to situate the argument, as outlined in the notice of application for leave to appeal, we rely broadly on the three grounds outlined in Section 17 of the Superior Courts Act, being Section 17A, Roman 1, Roman 2, and 17.1c. The primary ground, obviously, is Section 17.1a, Roman 1, and the other grounds will be interspersed, as it were, as we discuss some of those grounds. We state in the paragraph 3 of the note that if you look at the notice of application for leave to appeal, you identify the not less than 35, 37 separate grounds, which in the heads were reduced to 20. And now in this note, we have reduced further to 10. But those reductions, we stress, do not mean that we abandon any of the grounds. We simply wanted to highlight what we call the primary grounds, on the basis of which, given the constraints of time, we are quite confident that if on those 10 primary grounds, the court still finds that it is not inclined to grant leave, then even if we were to do the other 20, it would not make much difference. So we then go directly into those, which start at page 2 of the note under section B, my lord and my lady. And there we deal what we call, and this is probably the reason why we've elevated to the first ground, a very important ground that deals with the what we call the misdirections or defects in the judgment itself, the nature of the judgment. And one of the issues we raised there is the fact that we've identified about 13 areas where the court has simply not adjudicated on the disputes that were raised, or where it has so adjudicated has not given reasons for doing so. And this goes to the essence of what judgment is, in the sense that as even lay people know that the judgment constitutes conclusions and reasons, therefore, because it's an instrument for accountability, to account not just to the parties, but generally publicly, particularly in a matter of this nature. Now, against that background and the law which we will deal with, this court found, we start at page 109, where the court says it is not necessary for the court to express itself on the merits of the review in Part B. That's very important. We stress the words, it's not necessary. In other words, there's no need at all to express, for the court to express itself. And later it says, having undertaken no more than a peek into some, if not most, of the grounds, the learned judge then says, I'm nonetheless of the view that the applicant has not made out the clearest of cases and so on. So that's on page 3. If you look at the underlined words, that's where the offending parts are. Firstly, it cannot not be necessary for the court to express itself on the merits of the review in Part B, putting aside the next point, which is that this application is not a review application per se. But let's assume that it was. It would still be necessary for the court to express itself on the merits of the review. And secondly, most definitely, the court, even if it followed the new formulation, or rather the formulation espoused in EFF versus Godin, of having to take a peek into the grounds, which is the more correct formulation. And that's the part where the court said it couldn't see the difference between the EFF versus Godin test and the outer test. And that's one of them. In outer, for example, I think that's cited in one of the heads, probably I think it's the DA heads, where it's clear that in outer, Musanega DCJ specifically said that he avoided, and that's the word that is used, avoided looking into the review grounds. But in EFF versus Godin, that theory of avoidance is not countenanced. What is refined and evolved, at least there, is that should be a peek into the grounds, which is a completely different thing to avoiding the grounds. But we're saying, even if you take that test, the FF versus Godin test, of taking a peek into the grounds, then you must take a peek into the grounds, not into, as the court said, some, if not most of them. It should be all the grounds. So it's a misdirection to leave out some of the grounds, because that's the clear implication of that statement. And the issue is this, my lords and my lady. Let's maybe what causes a bit of blur in this matter is the fact that there were many grounds, even of review. We've said there's 2 or 3 grounds of review. So you have to postulate a situation where there were not 3 or 4 grounds of review, and assume that there was one ground of review, even out of the 3. Now, if you postulate that, then the point we're making will be very clear. Now, imagine if the court were to say, you've put this one ground of review, and it's not necessary, A, to look at it, and B, or let's say there were 2 grounds, and then we'll only take a peek into one, but not the other, then clearly the judgment will be deficient to the extent that it cannot possibly, the court cannot possibly assess the so-called likely to succeed test if it has not even taken as much as a peek at the ground that it is supposed to assess. And then there's a specific issue that we then deal with as another example. We made 13 examples in the notice, but we've reduced it to 5 in the note. We deal there, for example, with the failure to adjudicate on the issue of Malafides. Now, this is, of course, a crucial issue, the Malafides issue, for various reasons. And the court was enjoined to express itself one way or the other, because as we know, even if you take the Gool test, GOOL, then it is said that a mere allegation of Malafides would be sufficient to negate what is now known as the outer test. But even if you take the stronger articulation favored by this court of an allegation of Malafides is not sufficient, but you have to prove Malafides. On either one of those tests, the court would have to say whether the Malafides were alleged if you use the Gool test, or proven if you use the stronger test. But there's no scenario where the court might say nothing about the issue. And that's the criticism. So what has happened here is that the court basically on these issues basically said, look, the applicant said this, the respondent said this, and that's it. And then it moves on to the next issue without saying what. Of course, the applicant said this, the respondent said this, but we want to know, what does the court say about those two positions of the parties, sorry. Then similarly, on the crucial question of the legal representation, again, the court simply says, this one said this one said that, and that's it. We don't know whether the court, which position it takes, and if so, why. But, well, you don't even get to the why if there's not an adjudication on the issue. So you have two types of cases where there is an articulation, but there are no reasons. But the worst type is when there's no articulation at all. So you don't even get to the issue of reasons. And then the last example that we use in the note is what we call the double-barreled issue of the separation of powers and the ultra-virus in respect of the issue purporting to confer the power to appoint judges on the Speaker and or Chief Justice. I mean, you can just ask yourself a question. Did this court find that the Speaker has the power or virus to appoint a judge or not? Well, if you read the judgment, you will be none the wiser. It's one thing to say the court made an incorrect finding, which we could do. But here, the court did not make any finding. And so we don't know whether the Speaker of Parliament has the power to appoint a judge or not. And to do so, nohal, in consultation with the Chief Justice, which makes the Chief Justice an accomplice in such an illegality. So we'd like to know, I mean, it might be that we are wrong. Maybe the Speaker does have the power to appoint judges. Maybe the Chief Justice acting alone has the power to appoint judges. And if we are wrong on that, then obviously we can then criticize the judgment, but we can't even criticize something that is not decided one way or the other. And that particular point, I think is important for many reasons. it's important as follows, because what the court will then be saying, for example, let's assume that the court says, well, we find that the speaker does have the power to appoint a judge or whatever. Then that goes immediately into the question of even the outer test, assuming for now that it applies, as to whether is it likely really that another court in Part B will not find that the speaker is not empowered to appoint judges. And that point, my lords and my lady, comes out clearly from section 174 of the Constitution. That is the section that explains how judges are appointed and by whom in South Africa. So it's not a matter of debate, really. I'll just take one, because it's a long section, 174.6, which deals with the appointment of judges outside of the Constitutional Court judges. The president must appoint the judges of all other courts, in other words, not the Constitutional Court, on the advice of the Judicial Services Commission. So it's very clear. So if the president were to, let's say, if this rule that we are criticizing said the president will appoint the judge who's going to sit in the independent panel, then we would ask the question, where does the president get that power? And the immediate answer would be section 174.6 of the Constitution. But if you ask the same question apropos the speaker, there's no answer, at least not one that we know in our law. So, and you can't, not even the president could just wake up and appoint judges. He derives that power from 174.6. So the failure to adjudicate on such a crucial issue has two implications. One being the inability to assess it in relation to the test, but also the clear, the absence of a statement that says actually a court can find such a thing, that the speaker has the power to appoint a judge. And if we are right about that, let's just say for argument's sake, we are right that the speaker does not have the power to appoint a judge, and neither does the Chief Justice, then clearly that has an impact on the likelihood of that of the rules being unconstitutional on that ground alone. It just stands to reason. Now, the import of this ground is that the Constitutional Court has said so many times, particularly in Mpahlele, that a court has a duty. It's not an option. It's not like the court has an option to grant reasons or not grant reasons, or to adjudicate on a particular issue or choose which issue. It's duty bound. And this is what Goldstone J had to say in Mpahlele. There is no express constitutional provision which requires judges to furnish reasons for their decision. I'm reading at 8.1. Nonetheless, in Section 1 of the Constitution, Section 1 is one of the founding values of our democratic state, and the judiciary is bound by it. The rule of law undoubtedly requires judges not to act arbitrarily and be accountable. The manner in which they account for their decision is by furnishing reasons. And it says this serves a number of purposes. It explains to the parties and to the public at large, which has an interest in courts being open and transparent, why, that's the most important word, a case is decided as it is. It is a discipline which curbs arbitrary judicial decision. Then too, it is essential for the appeal process, enabling the losing party to make an informed decision as to whether or not to appeal where necessary. And further down it says, finally, it provides guidance to the public in respect of similar matters. It may well be too that where decision is subject to appeal, it would be a violation of the constitutional right of the access to courts. That's Section 34 now. if reasons for such decisions were to be withheld by a judicial officer. So let's pause there. So what the Constitutional Court said is that the failure to give reasons for a finding, even when it exists, let alone where the finding itself is not made, is a violation of the constitutional right of access to courts, which is Section 34. And then the learned Judge Goldstone said, courts of first instance, which this court is, invariably furnish reasons for their decisions, whether in criminal or civil cases. As I have already suggested, if they fail to do that, they might be in violation of a constitutional duty. So this is a serious matter, ground of appeal, which is based on what at least would amount to a violation of the duty to furnish reasons. And we want to quickly, if you go to page 5, we want to quickly preempt any suggestion that what we are talking about is the situation which is usually an unreasonable request that a judge or a judgment, for that matter, needs to cover chapter and verse of every word and every argument that was advanced. We know that that is not practical. And that was made clear in the case of R versus Rumayo a long time ago, where it was said that indeed, even in a written judgment, it is often impossible without going into the facts at undue length to refer to all the considerations that arise. Moreover, even the most careful judge may forget not to consider, but to mention some of them. No judgment can ever be perfect and all-embracing. It would be unsafe invariably to conclude that everything that is not mentioned has been overlooked. And we say that that's not what we're dealing with, so we don't want to go there. Here we're dealing with a specific situation where it cannot be said that the material that is left out has been overlooked or forgotten. No, this court has said specifically, we're not going to do it. We are not going to, it is not necessary to look into A, B, C, D, or even if when they didn't say so, they've just simply, as I say this one said this one said that, and then we go to the next one. The respondent said this, the applicant said this, then we go to the next one, and so on. So it's a completely different situation to where you are saying that the court, unrealistic situation of expecting the court to go into each and every argument. Now that, with the greatest respect, on its own should be ground enough for grant leave to appeal, even on the Section 17A1 1A Roman 1 basis, because the test there is simple. It's whether another court would take the same approach, whether another court would also find it unnecessary to pronounce on the very things upon which it is supposed to make an assessment whether they are likely to succeed or not in B, which it just doesn't make sense. And what is important, maybe before I move to the next ground, is that there's no use in us trying to convince this court that it should have, for example, it should have found that the speaker does not have power to appoint a judge. That's too late. That train has passed the station. So the court has found, or impliedly or directly, that there's nothing wrong with that. All we need to convince this court is simply that another court might not agree. That's all. And particularly a higher court. So otherwise we'll just be re-arguing the case and saying, no, the Chief Justice doesn't have the power and so on. There's no need for us to do that. All the court has to do now is, objectively speaking, to assess whether all courts in this country would find that, for example, the speaker can appoint a judge. And we respectfully submit that they wouldn't. Now, then we go to, as I say, from what I've said, you must subsume everything that is in paragraph 14 of the notice of application for leave to appeal. We don't need to traverse all 13 of the instances where the court simply did not adjudicate one way or the other. Then but we do isolate at B2 on page 6 the issue of the referral to legal representation. And we do that because this is an important issue. Again, one might ask the rhetorical question, will all the courts in South Africa find that, or well, at least the higher courts, find that the denial of full legal representation to the public protector or to the head of a Chapter 9 institution is constitutional? Well, we say on the grounds of the Hamata case, which says that the ability to be legally represented is a constitutional imperative, then clearly another court like the Hamata case, which was the SCA, and the SCA in this case is likely to find in the same way that it found in Hamata. This court found a different way, that's fine, but the SCA might just uphold its own decision in Hamata. And so that's just a possibility of that happening. I would say it's more than a possibility, but we're happy with leaving it at the lowest level of a possibility, a reasonable possibility or reasonable prospect. Now, we say also the statement of Etienne Murenik, which is well known, that there's a culture of justification, that our constitution has introduced what is called a culture of justification. So you can't just wake up and do anything you like. If you do, well, I suppose you can, but you have to then justify it when it's challenged in court. And we say here there's a positive act by the National Assembly. This is the clearest example of a positive act, because remember, these rules are modeled on the Section 89 rules. And here they have positively decided to add the words, provided that the legal practitioner or other expert may not participate in the committee. In other words, to limit or infringe that right. Now, that immediately kicks in the need for justification. That's why we have something called Section 36 of the Constitution. As soon as you infringe a right, there must be a justification. Otherwise, that infringement is unconstitutional. So here, what is the reason? Again, I'm just using the rhetorical question as a tool. And let's look at it like this, as we put it at paragraph 19. We know that there are three types of impeachments that we know in South Africa. It's the impeachment of a president, the impeachment of a judge, and the impeachment of a Chapter 9 institution. Now, when it comes to the impeachment of the president, he has full legal representation. When it comes to the impeachment of a judge, he or she has full legal representation. But when it comes to the impeachment of a head of a Chapter 9 institution, he or she doesn't. That might be the case, but then there must be a reason. In a constitutional democracy, then there must be a justification to say, okay, what differentiates the head of, apropos this point of legal representation, what differentiates the head of a legal, Chapter 9 institution from a judge or from the president, as far as impeachment processes are concerned? Well, the answer is absolutely nothing, or at least nothing that was advanced to this court. As I say, there might be differences, but if those differences exist somewhere but not here, then there's no justification for that inconsistency, or what is known as irrational differentiation, which is what the whole of Section 9 of the Constitution is aimed exactly at that, at what we call irrational differentiation, which is otherwise known as unfair discrimination. So, and as we all know from the Haxton case, you can discriminate, but there must be a justification. Here, there's none. So again, one might ask, is there no court in this country or no higher court that may find that there is, it is likely that there's no rational differentiation between a judge, a president, and a head of a Chapter 9 institution in this context. The answer is self-evidently there is a prospect of that, and is likely to succeed. Then we got retrospectivity. Again, there we say that the losing litigant, which is the applicant in this case, doesn't know whether the court found that there was an intention for these rules to be applied retrospectively, firstly. But if, let's assume somehow the court made that finding, why? We don't know. And therefore, we can't even begin to assess whether that ground is likely to succeed or not in part B. Then here's the big one, which is the non-compliance and interpretation non-compliance with and the interpretation of the provisions of Section 194. I call this big because it's actually probably the most tragic of the failure to deal with the issue that has been raised by the parties. Why? Because this court took the view, rightly or wrongly, that it will not adjudicate upon the introduction of a new ground of impeachment, and I call it that deliberately, called temporary incapacity. And the court said that is because Ms. Mkhwebane is not charged with temporary incapacity, or incapacity for that matter, which is obviously true. But that actually has absolutely nothing to do with the point that we were raising. Because the point we were raising was not that Ms. Mkhwebane herself is charged with this or that or the other. It was the point was that the rules are unconstitutional by introducing a new ground that is not postulated by the Constitution, which is a serious matter, a very serious matter, if we're right. And the problem with that, and that's a question, that's a pure question of interpretation of the Constitution. It's got nothing to do with Ms. Mkhwebane or anybody for that matter. It is whether the words in Section 194, which say that the public protector, the auditor general, or a member of the commission established by this chapter may be removed from office only on the ground of misconduct, incapacity, or incompetence. So it's very clear there that the founders of the Constitution, or the drafters, the mothers and fathers of the Constitution, use the word only for a reason. They don't. We have to assume that they don't use words just because they are there. So it was clear that it was a restriction. You can only be removed only on the ground of misconduct, incapacity, and incompetence. So the introduction of a fourth ground through the back door by the legislature is unconstitutional, plainly, because it offends a plain interpretation of that section. That's the issue we're raising. So it doesn't matter if Ms. Mkhwebane or Ms. X or Ms. Y is charged with this or that. The question is whether the Constitution has been violated in that a new ground, whatever the ground is, it could be sleeping at work or whatever, whatever that ground is, as long as it's not one of the three that are clearly proscribed in a limited fashion by the Constitution. So that was an opportunity to deal with that issue was lost, because then it was because of this issue about but she is not charged with incapacity, and and so we say there that we make that point at page 9, the emphasis on the word only, and we say to deal with this attack, it is immaterial whether a particular aggrieved head of a Chapter 9 institution has or has not been charged with such an improperly or newly introduced offense. The introduction is either constitutionally valid or it is not. It's purely a matter of interpretation. Let me pause there. The difference between a complaint about how the rules have been applied in a particular case and the complaint about the interpretation of the rules. And that also ties up with another point, by the way, which is the court's issue of separation of powers. It was made clear in the EFF impeachment case, and we deal with that at page 10, where Chapter J said, conceptually, it is difficult to appreciate how the interpretation and application of a provision in the Constitution by a court of law can amount to judicial overreach. In other words, the issue of separation of powers does not arise when we are dealing with the interpretation of a constitutional power, because the only body that is entitled to interpret the Constitution is the court. So there's no separation of powers between who and who, because there's only one entity that can interpret the Constitution. So again, that question of interpretation, then coming to this test, because again, we must always refrain from trying to re-argue the case. The only thing that this court has to determine is whether another court, a higher court, there are reasonable prospect that another court will find that the word only means only, and it means that you cannot expand the rules of, rather, the grounds of impeachment. That's all. So if this court will either find that, well, there's no court that will ever find that the word only means that it's only those three things and not a fourth one, irrespective of whether someone is charged with it or not. Or the court will find that it's not likely that another court will find that only means only. And then the court will then have to refuse leave to appeal. Then we then say that then the court also made what we call a point of aggravation, because the court said in our supplementary note in reply, the applicant abandoned the point but sought to persist with their complaint about the definitional content of the new rules relation to misconduct and incompetence. Well, at least speaking for myself, I can assure the court that there was no such abandonment of the ground based on the introduction of temporary incapacity. What simply happened is that we said there, because we had this long debate about, well, she's not charged with it and so on. So we said, okay, to avoid, at 3.1, to avoid any further confusion, we hereby drop that illustration, because it was pointed out by the court that it is not charged with incapacity. The exact same point, underline that, then and is hereby made by reference to the definition of misconduct or incompetence. What is the exact same point we're referring to? The exact same point was the point that only means only, and it cannot be expanded. So that point was never abandoned with respect. Then we tie that up with the next point, where the court, again, with respect, missed the gist of what the complaint was here. The complaint here, my lords and my lady, was that insofar as the National Assembly introduced a new offense of temporary incapacity, and putting aside the absurdity of that notion that temporary incapacity can be an impeachable offense. I mean, that means if you walk around and you sleep and break your ankle and you are temporarily incapacitated, you can be impeached. Surely that's not what the founders of the Constitution had in mind. So, but put aside that absurdity. The point we were making is that anybody, any human being, you cannot take away existing rights from a person without consulting them. to put it at its lowest. And therefore, insofar as these rules are being introduced midstream through the contract or through the employment or through whatever you call it, the engagement of the public protector, then that is altering, that is introducing a new offense, so is obviously altering the disciplinary code if it was a workplace. And the court then went on to this question of whether the public protector can be described as an employee. That has nothing to do with it. It could be an employee or a soccer player or whatever. Any human being you cannot in the middle of an engagement change or alter the conditions of that person without consulting them. That sentiment was captured in the case of Premier of Bubalana, where the court says it may be that the retroactive termination, that's page 11, of benefits will not be fair, no matter what process is followed, unless there is an overriding public interest. Citizens, not employees or short people or tall people or whatever, citizens are entitled to expect that government policy will ordinarily not be altered. And that's where the thing is the alteration, in ways which would harm or threaten their rights or legitimate expectations without their being given reasonable notice of the proposed change or an opportunity to make representation to the decision maker. And this is what we were saying. So if the National Assembly is probably entitled to change the terms of the people who account to it, it can probably change the conditions of everyone. It can say, well, the ministers may no longer travel or whatever. But so that's not what we are quibbling about. But we're saying if you are going to do that, you must have the person adversely affected, give them a chance, A, notice, and B, a chance to make representations. Both of those were denied in this case because notice was not given. It was given to the media even before it was given to the public protector. And certainly there was no opportunity to make representations. That's common cause. Then we then move to the separation of powers and ultra vires. I'll jump this for now because that is I've addressed it in a different context. Save just to say that here it is tried that legislation which violates the principle of legality will be inconsistent with the Constitution and invalid. In other words, if it is true that it's ultra vires the Speaker to appoint judges, then that ipso facto is valid, would invalidate the rules. And no one can say it's unlikely that a court will find so. Then we come to B6, which is the point we call the mischaracterization of the relief sought. This is again another serious matter. Let me just articulate it like this. The court classified the 10 grounds that we articulated as grounds of review. And we say that's a fundamental error. Only 2 or 3 of those grounds are grounds of review. The rest of the grounds are grounds of unconstitutionality. So they are based on section 172 of the Constitution. And this court said in more than one place that we only raised this question of 172 and the suspension in reply. The counsel for the applicant only raised this in reply and so on. Well, nothing could be further from the truth. If one will go to part A of the notice of motion, which is summarized in the judgment, paragraph 3, I mean at page 3, says that we say that the Speaker must be interdicted, and then we say they must be prohibited from taking any further steps in the implementation of the process. Now, just at a simple language level, taking any further steps in the implementation of the process. If that is not suspending something, then nothing ever will be. Because you're saying taking any further, the word further means some steps have been taken. And then in the implementation, which means it's ongoing, or a process, which means it's an ongoing process. So if you stop from taking any further steps, it's like suspending a strike that is already ongoing. If you, so that is asked for if you like, in so many words. But if that is not enough, you can go to paragraph 8 of part A, where we say that we pray for just and or equitable relief, or which is, those words are taken directly from section 172 1B, just and equitable relief. And that would cover not only because this thing was pleaded, as we showed in the letters and in the affidavits, but it would cover, certainly cover the relief postulated by Chapter J in the EFF case. And while we are there, just in case, so that I don't forget, the suspension order that was postulated by Chapter J is wrongly identified as if it's just another alternative to the outer test. Well, the Chapter J could not have been clearer than he was at paragraph 113 of the FF versus Godin case, where he says, and you'll find that at paragraph 55 of the note, he says, the outer standard does not apply to suspension, does not apply. And why is that so? Because under section 172.2, remember that the relief that is sought there starts with 172.1a, where the court must declare something that is unconstitutional to be unconstitutional. The court has no discretion there. So the outer test could never apply to a situation where the court is compelled to do something, just from logic. So that's why the Chapter J says that the outer test standard does not apply to suspension. So all that we really need to convince this court is that the suspension of the process is postulated in the notice of motion, both in prayers 2 and 8. And if that is so, then an end is pleaded to make it worse. And it's even in these heads, in the current heads, if you go to the heads of argument of the speaker, for example, it's uncanny how they say at paragraph 6.1, as regards the test for interim integrity given in particular facts, the public prosecutor had to show but did not show a very compelling case on the merits, nothing short of which would justify, they say, the exceptional remedy of staying the section 194 process, which is underway. Staying, suspending, stopping from further ongoing process and so on. That's the same, all of that is the same thing. So even they themselves postulate that this involves staying or suspending the what you call the process. So there really is no ground upon which. So what Chapter J did, although the court admittedly says it didn't see the difference, but what Chapter J did was to postulate what we call an alternative pathway to a suspension without having to go via the outer test. And that is something. It might not be a big thing, but it's quite something. So that's a development in our view of the outer test, quite apart from the fact that the avoidance test in outer has now been nuanced into the picking test. Now, can I quickly then go to I'll jump the B7 because that's related to B6. Yes, B7 is related to B6. So it's a broader point. The first part of that point is that the relief the strikeout and the cost order. There, I think our learned friends on the other side have also misunderstood what we are saying there. We are saying there two things. One is that you'll remember that when we started the case within, let's say generously, the first 20 minutes here or 10, it was said that, look, the condemnation and the strikeout is in. And so what we're saying there is not so much that because the analysis or the counter analysis deals with one of the legs that we complain about and not the other. There are two important things which must be distinguished from each other here. One is the failure to file an answering affidavit. That's one thing. That there's no explanation for that. I mean, but as I say, it's too late. That train has passed. But the second one, which is a separate thing, is particularly in the case of the DA, is the refusal and failure to even apply for condonation after being prompted to do so in the replying affidavit in March, April, May, June, July, and then wait until August, in the 6th month, when you've been told in an affidavit, put an application, not that it's whether it's good or bad or indifferent, just put something, please, just to respect the court. and they just refuse to do so. And they do it on the day before the hearing, on the 11th. The hearing was on the 12th. And then we are told there's no prejudice. How can there be no prejudice? At what point are we supposed to respond to that application? Because the reason we were crying out for this application in the letters and in the reply is so that we can deal with it. If it was put in the answering affidavit, like the one of the speaker was put, wishy-washy as it was, but at least it was put there, then we were able to respond to it in reply. But the one of the DA, you can't respond to something that's not there. Now, how can that be? The court said, I can't remember the words that were used. There was no. Sorry, I want to read it verbatim.
Mr. Mpofu, please watch your time.
Yeah, yes, I know. I'm sorry, my lord.
I'm just reminding you to watch your time.
Yes. Oh, yes, my lord. I'm going to wrap up just now. I'm indebted to it.
Were you looking for something in the judgment?
Yes, yeah. It is paragraph 136. Given the scenario that I've painted, the court then says that it cannot find that this conduct that I've just described was unnecessarily deleterious. But anyway, so and we're talking here about, as I say, a complete failure for 6 months to even apply, let alone to put the requirements and all that, but simply just to apply. I mean, that is deleterious and is unnecessarily so. Not only is it that it's prejudicial to the other party because you are unable to deal with it. And what then happens is that despite all this, the court then says the cost of that application that came a day before, are to the cost and the cause, which means that the applicant must pay the cost, must pay the DA for waiting for 6 months before the reward is that they must get the cost from the public protector. I mean, anyway. So, but I think the only issue really one can say is that surely another court might find that the complete absence of an application for condemnation is unnecessarily deleterious. And as I said, we can't change that. This court found that it is not, because the court is functus officio. Even if we could change it, there's nothing the court can do about it. We're projecting forward now to the next court. Another court we are confident, not almost, would find that such conduct is unnecessarily deleterious. Then, in wrapping up, then, my lord, I'll just take 5 minutes. I'm not going to go into the.
Mr. Mpofu, you wanted 45 minutes. You're now well over your 45 minutes. There are others who must also argue. You can deal with whatever is outstanding in reply.
Are you stopping me? Must I stop talking now?
Yes, because your 45 minutes is over.
Okay. Thank you.
Okay, thank you.
As God pleases.
Thank you, Mr. Breitenbach.
Thank you, my lord. I will be as brief as possible, mindful of the hour. I'm going to deal with the 10 primary grounds that my learned friend has mentioned in his note. I'd like to start with B1, the material misdirection or defects. which is regarded as said to be the most important, and it is a failure to adjudicate with quote, some of the key issues raised, which, having listened to my learned friend, really amounts to this. It's a criticism of the court's peek into the grounds of challenge, which are raised in the intended to be raised in Part B. Now, with great respect, the entire approach of my learned friend inverts the inquiry, not just in relation to this application for leave to appeal, but in relation to the main case. You see, the thing is that in order to succeed, his client had to show not just a very compelling case on the merits, but also a reasonable apprehension of irreparable and imminent harm if the interim relief is not granted and she's ultimately successful in the Part B challenge, that she has no suitable alternative remedies, and crucially, that any harm that she will suffer is outweighed by the serious prejudice to the separation of powers and the public interest in the timeous conclusion of the Section 194 process that will ensue if the interim interdict is granted. This court would have been entirely within its rights to focus solely on some of those requirements and say they weren't met. And what we have is notable in its absence in my learned friend's submissions. He even jumped over the paragraph or ground B8, irreparable harm and adequate alternative remedies, in his note, is any substantiated criticism in the sense that one can say with a measure of certainty that this court's dealings in the judgment paragraphs 110 to 117 with the irreparable harm issue, that its dealings in paragraphs 116 and again 122 to 127 with the availability of suitable alternative remedies, and perhaps most crucially, its dealing in the judgments paragraph 118 to 121 with the obvious mismatch between the harm which the public protector claimed and the serious prejudice to the separation of powers and the public interest that I've mentioned. I'd add one further thing in this regard. As this court, with respect, correctly pointed out in its judgment at 127, para 127, even if the requirements for the interim interdict had been satisfied, which they weren't, the court has an overriding discretion to grant or refuse the interim relief. In paragraph 127, the court gave its reasons for saying in any event it would have exercised its discretion against the public protector. I don't need to repeat them here. And I respectfully submit there is no prospect of the Supreme Court of Appeal holding that this court was wrong, let alone that it didn't exercise its discretion judicially. We've dealt with these points in paragraph 6 of our heads of argument. The court's read them and I won't repeat them. Moving then to some of the criticisms of the judicial peak. B2, legal representation. My learned friend's submission is quite far-reaching. He says essentially that Rule 129 AD sub 3, which permits a legal practitioner to assist the holder of a Chapter 9 office in proceedings of a committee established in terms of Section 194, but provides that the practitioner may not participate in the proceedings of the committee, is irrational. And it is unexplained, he submits, having regard to the other types of impeachment proceedings for the President and judges in the Constitution. With respect, it's not correct that it is unexplained. It's dealt with in the Speaker's answering affidavit at pages 269 to 270, paragraphs 179 to 184. As the court will recall, in essence, what the Speaker said is that Section 194 is the ultimate accountability mechanism by which Chapter 9 office bearers may be held accountable by the NA, and it's therefore important that they themselves and not their proxies participate in the committee proceedings required by 1942, if it comes to that. To that, we would add a point made by the court in its judgment in paragraph 89, and that is that Section 129 AD sub 2, the immediately preceding provision, requires that the Section 194 committee conduct its inquiry in a reasonable and procedurally fair manner. And as we submitted, while the committee may not permit a Chapter 9 office bearer's legal representative himself or herself actually to participate, should a situation arise where reasonableness or procedural fairness require that the office bearer be afforded time to consult their representative before proceeding, for example, before questioning a witness against them either generally or on a particular issue, a reasonable or fair period has to be afforded under the rules for them to achieve that purpose. The next point is retrospectivity. Much debated on the previous occasion, and again, much stressed again today. There are a couple of points to be made in this regard. The first is that the new rules do not introduce a lower threshold for the two grounds of impeachment which are relevant to the public protector, namely misconduct or incompetence. My learned friend's point about temporary incapacity, I don't even want to go into the merits of that. That's a debate that we'll be having in Part B in early February if the Judge President gives us a full court. But with respect, it's totally irrelevant to an application for an interim interdict by someone who's not facing impeachment on the ground of temporary incapacity. In any event, despite what my learned friend has submitted to you today, it was in fact abandoned during argument for that very reason. And we're dealing with an application for an interim interdict pendente lite, which must show harm. What possible harm can the public protector suffer in connection with the introduction of temporary incapacity as a ground for impeachment in the rules, when the motion in question doesn't mention that? I shan't go into why the threshold is higher. We have done so. We refer simply to the definitions of misconduct and incompetence in the new rules. As far as retrospectivity is concerned, the key thing about that is, to put it colloquially, changing the goalposts after the fact to the detriment of someone. If as has happened in the cases of incompetence and misconduct, the bar is raised, it in fact operates to the benefit or potential benefit of Chapter 9 institutions in any case. There is in any event no general rule in our law against retrospectivity, as this court pointed out in its judgment. That takes care of B3 and B4 of the note. B5, the separation of powers issue, the appointment of a judge. Now, in that regard, the first issue is whether the serving of a judge on the independent panel is something which is incompatible with the functions of a judge. In the Speaker's answering affidavit, she explained why, with respect, that is not the case. What we're dealing with here is an evaluation of evidence to determine whether prima facie a case is made out to take the matter forward, the sort of things that judges do every day, evaluate evidence and form a judgment, sometimes prima facie, as in an ordinary application for interim relief. The so-called complicity of the Chief Justice in this is anything but that. The requirement that it's in 129(v)(3), that if a judge is to be appointed, the Speaker must do so in consultation with the Chief Justice, is designed precisely to protect the integrity of the judiciary. The head of the judiciary has to agree to the appointment of a judge at all, or a particular judge, having regard obviously to the requirements of the judicial branch at the time. So we submit there's really nothing in that point, but again, it's something that we will be debating in part B. The point being that my learned friend had to show this court a compelling case, and for the reasons that I've just given, the case was far from compelling. That brings me to B6, the supposed mischaracterization of the grounds of attack as grounds of review. With great respect to my learned friend, for the reasons given in paragraphs 8.1 to 8.4 of our heads of argument, which I won't repeat, that criticism is unfounded, and there is no prospect of an appeal court coming to the Public Protector's assistance in that regard. Then Section 172 of the Constitution, a curious point, curious for a number of reasons. The first is that my learned friend fetches it in the essentially in the prayer for further and alternative relief, which has been reformulated, somewhat differently formulated, and I'm sorry to having to stretch further in the alternative, just and equitable relief as this court may deem appropriate. So it's an unusual place to find what my learned friend says in his note in paragraph 53 on page 15 is, quote, a case that was always premised on section 172.1a and 172.1b. Well, with respect to him, we didn't hear much about that in his very lengthy address, which focused on the outer test quite correctly. In any event, in its judgment at paragraph 131, the court did consider the court's invocation of section 172.1b of the Constitution, and having assessed the factors on both sides, concluded that it wouldn't be just and equitable for the process for the removal of the Public Protector in terms of the new rules to be suspended. The only thing that I would add to that is that it's far from clear, certainly not compelling, that 172 is applicable in a case of this kind. Well, with respect to what my learned friend's reliance on JAF2J and the alternative pathway in the Gordon case, as I recall, the reason I say that is that 172.1, it deals with two things. 172.1a imposes a duty on the court when deciding a constitutional matter within its power to declare that any law or conduct that's inconsistent with the Constitution is invalid to the extent of its inconsistency. That's a mandatory obligation. It cannot be avoided if a court reaches that conclusion. The provision which he relies on, 172.1b, is a derivative of that, because it says, and the court may make any order that's just and equitable, including an order limiting the retrospective effect of the declaration of invalidity and an order suspending the declaration of invalidity. The point I wish to make, and this is where the lack of clarity comes in, is that it is strongly arguable that in a case like this one, which is an interim interact pending proceedings for review or an order of unconstitutionality, which is how the notice of motion before you Part B was framed, that 172 operates in the Part B phase, not the Part A phase. Part A is outer. The Concord in the line of cases hasn't hung its hat, to put it colloquially, on section 172.1b. So with respect, a compelling case on that point, I respectfully submit that's not the case. B8 I've dealt with, irreparable harm and inadequate alternative remedies. The point about reasons in B9, with respect, I just failed to understand. We know that the operative complaint is Ms. Mazzoni's complaint, which came in during February this year. We know that in her answering affidavit, the Speaker gave detailed reasons for that, her decision that prima facie, in other words, on the face of this complaint, it complied with the formal requirements of the rule and was complied with the law and the Constitution. In other words, she gave the reasons. I didn't even understand my learned friends on the last occasion to argue that for an order compelling the Speaker to give reasons, because the reasons were there. The complaint was about a previous motion which had been withdrawn long before the court, this court came to adjudicate the matter, and indeed before the answering papers were filed. On the issue of condemnation, strikeout and costs, we're dealing here essentially with discretionary decisions. The question is there a prospect of the SCA interfering with the exercise of this court's discretion? In other words, holding that it did not exercise its discretion judicially. Paragraph 11 of our heads of argument, we submit that there's no prospect of that whatsoever. My Lord, I've made certain other points, or we've made certain other points in our heads of argument, including a point about some of the tone and content of the language in the notice of application to appeal. I will leave those matters there. We stand by our heads of argument. Unless there are any questions, those are our submissions.
Thank you.
I'm sorry, my Lord, I can't hear you.
Can you hear us? Can you hear me?
Yes, I can hear you.
Thank you, Mr. Breitenbach. That's all.
Thank you.
Mr. Butler, thank you.
Thank you, my lord. Can you hear me?
I can hear you, thank you.
Thank you very much, my lord. My lord, I've listened carefully to the address by my learned friend, Mr. Breitenbach, and I do not propose to repeat what he has said. I would emphasize only the following 4 points briefly. But before dealing with the following 4 points, I must make a general point. And it touches on what Mr. Breitenbach said. But with great respect, the fatal flaw in the address that you've heard is that it overlooks the fact that there are 4 requirements for an interim interdict to be granted. The first is the existence of a prima facie right. The second is a showing of irreparable harm. The third is a balance of convenience. And the fourth is an absence of alternative remedies. And the argument that you've heard from our learned friend for the public protector today focused almost entirely on the first question, whether there was a right that had been infringed, or what he called the merits of the review grounds, or the merits of the constitutional challenge. But even if you assume that he is correct on every word he said, and that he has a compelling case in respect of those grounds, which he doesn't with respect, but even if you assume that he does, it doesn't help. And the reason is that this court rejected all 4 of the requirements in this case. It held that there was no showing of a prima facie right, but it went on at paragraphs 110 to 117 of its judgment to show that there was no showing of irreparable harm. It went on to hold at paragraph 118 to 121 that the balance of convenience was not satisfied. And it went on at 122 to 125 to hold that there were alternative remedies. And that is the reason that this court concluded at paragraph 127, the applicant has, in my view, failed to meet any of the requirements for interim relief. And so even if my learned friend had persuaded you that he had reasonable prospects on the first requirement, that doesn't help him with the second, the third, or the fourth. And on the second, the third, and the fourth, you've heard essentially no argument from him. And even when we go to his notes, the notes deal with irreparable harm and adequate alternative remedies at paragraphs 56 to 59. But when you read those paragraphs, they are threadbare. There is really an assertion that there's irreparable harm and adequate alternative and no adequate alternative remedies, but they are threadbare. And with respect, that ought to be the end of this application for leave to appeal, with even on the ordinary standard, even on the pre-Superior Courts Act standard. Because if he can't come home, or his client can't come home on irreparable harm, balance of convenience, and alternative remedies, then all of the argument you've heard on the merits grounds is simply irrelevant. So we submit that really you need go no further than that to refuse leave to appeal. But nevertheless, for the sake of completeness, let me deal with 4 points very briefly in a way that hopefully complements rather than repeats the address of my learned friend, Mr. Breitenbach. And the first is, I want to say a word about this complaint that the court failed to decide the merits grounds, whether you call them the merits grounds or the constitutional challenge. And with respect, not only did this court not err in doing so, it did exactly what the Constitutional Court has twice held that it should do. In the outer case, at paragraph 31, the court said that in determining the merits of the interim interdict, quote, paragraph 31, to do that, I do not need to determine the cogency of the review grounds. It would not be appropriate to usurp the pending function of the review court and thereby anticipate its decision. And then in paragraph 48, it said the same. It said that, that after having heard full argument on the merits, I'm unable to say without more that they bear any merits, any prospects of success. That decision I leave to the review court. So that's exactly the approach that this court quite rightly adopted. It didn't go into the mud or the details of the review grounds. So then my learned friend says, no, but everything was changed in the Gordon case, because the Gordon says you have to take a judicial peek. With respect, that's not what the Gordon case says. It's the Gordon judgment at paragraph 42, which this court quoted in paragraph 20 of its address. And what was said there is it said the following. In addition, before a court may grant, and if I could underline the word grant, before a court may grant an interim interdict, it must be satisfied that the applicant for an interdict has good prospects of success in the main review. The claim for review must be based on strong grounds which are likely to succeed. This requires the court adjudicating the interdict application to peek into the grounds of review raised in the main review and assess their strength. It is only if a court is convinced that the review is likely to succeed that it may appropriately grant, and I underline the word grant again, the interdict. So what the Concourt was not saying is that a court dismissing an interim interdict has to always look into the review grounds, decide them, or even have a judicial peek. All it was saying is before you grant an interim interdict, you obviously have to have a look at the review grounds. But this court didn't grant an interim interdict, and it didn't grant it for very good reasons, because there was no showing of irreparable harm, there was no showing of a balance of convenience favoring the public protector, and there was no showing of an absence of alternative remedies. And so just as in Outer, it was entirely unnecessary for the court to deal with whether there were good prospects in the review, because this court was not granting an interim interdict. So far from erring, far from misdirecting itself, this court did exactly what the Constitutional Court has made clear was appropriate. It laid out the grounds, it heard full argument on them, it considered them, but it didn't decide them. Why not? Because as the Concourt said, that would usurp the pending function of the review court, or in this case, Part B. And that, with respect, takes care of virtually every argument that our learned friend has advanced today, because they all went to the merits. That's the first point I would make. The second point I would make is I do just want to say one word about this temporary incapacity point, because my learned friend simply couldn't be more wrong. He says that if the rule is bad because it allows for removal on temporary incapacity, then that's good enough, even if Ms. Mkhwebane is not herself accused of that. It is just simply wrong. And if I could give the court the reference, I may have given it in argument last time, I cannot recall. It's the matter of de Ruyck. De Ruyck versus the Director of Public Prosecutions, 2004-1, SA 406 CC, where exactly the same issue arose. Could the court strike, there it wasn't interim relief, that was final relief. Could a court strike down a statute dealing with child pornography because one person was involved who was not a policeman because he said it unfairly hit policemen? And the court said, well, notionally you can raise that because of the objective theory of invalidity. So we won't bar you at the outset. But we're not going to strike it down on that point. Why? Because as the court explained, absolutely clearly, it said, even if it were right on that point, even if it was bad for police officers or lawyers or judicial officers, it would not result in the section being set aside. There would be a less intrusive means. And that is the end of the point. Even if the point were good, the remedy would be to strike down the removal for temporary incapacity. That doesn't assist the public protector in Part B. It doesn't assist the public protector in Part A. It is utterly irrelevant. And the fact that my learned friend spent so long dealing with that point, with great respect, demonstrates the weakness of his case on the merits. The third point, the question of condemnation, my learned friend argues as though there was some showing of prejudice, but he overlooks the fact, of course, that his client had already replied to the answering affidavit. His client had already referred to the answering affidavit in the heads of argument. And now he asks that this court somehow erred in respect of the granting of condemnation for that same answering affidavit. With great respect, there is nothing in the point, not least because we know that condemnation is a discretionary issue and that in order to overturn it, a court would have to be satisfied that this court committed a demonstrable blunder in the exercise of its discretion. That language hasn't even been used. We haven't even had the language of the interference in discretion used. But what's really revealing with respect is that even after the public protector pares down her first 37 grounds to the next 20 grounds and then to the 10, there is still a point about condemnation and costs remaining. Well, that with respect demonstrates the strength of the other arguments. If that's one of the 10 best points that the public protector intends to advance on appeal, it demonstrates that the appeal simply is without merit. If the public protector's got a case, it's a case to be advanced in Part B, and it can still be advanced in Part B, and nothing this court has done will preclude that, but it doesn't. It certainly is no basis for a leave to appeal to be granted here. Very lastly, my lord, just to make sure that there's no misunderstanding, the notice of appeal suggested that some sort of declaratory order would be sought, directing that the order of this court is suspended pending appeal. It was not addressed in the heads of argument for my learned friend and hasn't been addressed in oral argument. But let me, just to avoid any doubt, let's be clear. We have addressed that in paragraphs 33 to 35 of our heads with reference to the judgment of Mr. Justice Harms in the Snow Delta case. And it makes clear in words of one syllable that the dismissal of a claim or application is not suspended pending appeal, simply because there is nothing that can operate or upon which execution can be levied. In other words, there is no suspension here because there is nothing to suspend. The position before the order was granted is there was no interim interdict. The position after the order is granted is that there's no interim interdict. But you can understand why this is important. We don't want the public protector contending via the back door that somehow this appeal or any subsequent application for leave to appeal suspends things. It doesn't. Snow Delta makes that clear in words of one syllable. And if there were any doubt on it, it resolves that doubt. So we submit that the application for leave to appeal should be dismissed. It should be dismissed with costs. I appear alone today, but my junior was on the heads, and we will ask for the costs, including the costs of 2 counsel, where 2 were employed. Thank you, my lord.
Thank you, Mr. Bartendam. Ms. Pillay.
Thank you, my lord. My lord, we filed heads of argument, and I will focus only on 3 issues in the 5 minutes that I've requested. My lord, the first is to highlight that the only relief that's been sought in relation to the president in this matter is the alternative relief sought in paragraph 3 of the notice of motion. And your lordship will be aware that that relief seeks an order interdicting the respondents and or their members who have a conflict of interest from voting and or participating in any way in the processes carried out in terms of section 194 of the Constitution and the rules.
Sorry to interrupt, Ms. Pillay. Do you mind showing yourself a little bit more?
Oh, I'm sorry, my lady. My apologies.
That's very nice. Thank you very much.
Thank you, Justice Stone. The second point I wanted to make is that this court dismissed the application, including the relief sought in prayer 3. In dealing with the relief sought in prayer 3, this court, if I could give the court the reference at paragraph 132, this court made three points. The first was that it found that a case had been made out for interim relief in the founding affidavit in circumstances where the relief actually sought was final in nature. The second is it expressed a concern about orders being sought and granted in circumstances where the parties against whom it would apply were not before court. And thirdly, it reached the conclusion that the issue of conflict was adequately catered for, both in the rules and the ethics code. All 3 of those issues are pertinently and expressly dealt with at paragraph 132 of the judgment. Now, my lords, my lady, there's no specific grounds of appeal that have been lodged in relation to any of these findings. And we would submit that none of the generic grounds, in other words, the grounds pertaining to the failure to deal with certain issues, the grounds in relation to the auto test, etc., none of those generic grounds find any application in respect of the findings that were made at paragraph 132. And for that reason, we submit that that ought to be the end of the application for leave to appeal insofar as paragraph 3 of the notice of motion goes. But there's one further reason, my lords, my lady, and that is that even if a leave to appeal were to be granted, we would submit that it would have no practical effect. And that's because of what's stated in the President's heads of argument at paragraph 17, where it stated that even though the relief sought in Part A of the notice of motion has been dismissed, the undertaking that the President's given not to determine this while proceedings are pending will remain in place. And for that reason, we say that it would have no practical effect of any kind. And for those reasons, we too submit that the application for leave to appeal ought to be dismissed with costs of 2 counsel where so employed, my lord. Those are my submissions, my lords, my lady.
Thank you, Ms. Pillay.
Thank you.
Mr. Mpofu, you're back on your feet.
Thank you, my lord. If I may start with, maybe let me just start with that last point from the president, because it actually illustrates some of the points that we're making about this judgment. The president Thank you very much for the undertaking. But that's not the point. The point is that, for example, the president comes here. We say this court must issue a temporary interdict for the president not to breach his duty against conflict of interest. The president actually comes here and concedes one of the grounds, but the court dismisses the application in relation even to the relief that is effectively conceded. So the result of that is that because we want to be protected by a court order, but we can't. So now we have to be protected by some voluntary undertaking that can be revoked at any time. That's the essence of what is wrong with this picture. Because what the president said is there are two grounds upon which you are alleging that I should be disqualified. One is the ongoing litigation in the Busasa case, where he says there's a potential conflict. He concedes that there's a potential conflict, or accepts. The word that they prefer is accept. And then he says the second one is based on the findings of the public protector in her report, in the Busasa report. And he says, I dispute that one, that second ground as a source of conflict. But the point I'm making is that even on the ground that he concedes that there's a potential conflict, which is the ongoing Busasa litigation, this court found that he was wrong, basically, and dismissed the application. But the importance of that, it doesn't end there. Remember the president's conflict. The point we make about the president's conflict, and forget about the one he disputes. Let's just talk about the one he concedes to. The point we make is that that conflict that he concedes to is exactly the same conflict that attaches to the speaker and the DA, which is let's call it the ongoing litigation conflict or potential conflict, whatever you call it. That, as far as the speaker is concerned, the Busasa case is the very same case that the president finds a potential conflict in respect of. But for some other unexplained reason, that doesn't apply to the speaker. And then the DA has also ongoing adversarial litigation about the spy allegation, which is the same type of conflict that the president says shows a potential conflict of interest. But again, that doesn't apply to the DA. So even the conflict that the president concedes is not good enough for the court to find that there might be a potential conflict in respect of the other people who are in the exact same shoes. I mean, that's just so that's the issue of the president. We not that we don't appreciate the undertaking, but would rather that we were protected by a court order like everybody else. Anyway, on a lighter note, I wanted to say that Mr. Badlander says that for the condemnation point, I should have alleged a demonstrable blunder on the part of the court. Well, it means he is in the head of Mr. Breitenbach. If I had said that, Mr. Breitenbach would have probably said I should get the death sentence. Because according to Mr. Breitenbach, even using words like improper is an insult. So if you say a court improperly exercises discretion, you're insulting it, or unduly did that. I mean, I've never heard of that kind of thing. So imagine if I had used an expression like the one Mr. Padlender wants me to use, for blunder. Ooh. And the fact that Mr. Padlender himself in his head accuses us of impropriety, I can tell you we don't take that as an insult to say that we improperly invoked a particular standard as against another. That's the language that's used in court, unduly, improperly. But anyway, it's obviously an attempt to try and I don't know what provokes something. Now let's come to the real issues. Both my learned friends let's start with Mr. Badlander's analysis. Mr. Badlander forgets that what we are saying about the irreparable harm, for example, and it might be threadbare in his estimation, but those are serious points. One, that we have said this before, the harm that is discerned by the public protector is the same harm at paragraph 67 of EFF versus Godin that was said to be discernible harm. So the fact that somebody else might not be able to discern it does not mean that it's not there. It says, on the other hand, Mr. Godin may suffer discernible irreparable harm and prejudice should the interim interdict not be granted. And then it goes on, I don't want to repeat, we all know that it says the mere fact that you are going to face disciplinary proceedings is such discernible harm. So that's not threadbare, that's a serious statement by the Constitutional Court of South Africa, that harm is discernible and irreparable. Secondly, this court then said that, I can't remember the paragraph, it says that it goes back to this thing of not deciding some of the issues. It says that there are, I think the word that was used was, sorry, I'm sorry, it said, you'll find that at B8. Yeah. Paragraph 125, paragraph 58 of the note. The court stated in paragraph 125 that the applicant has very real options of alternative remedies and has likewise failed to meet this requirement of interim relief. Full stop. If you take someone from the street to read the judgment and say, what alternative remedies did the court find? Zero. There's there's nothing. At paragraph 125, all the court says is the applicant has very real options. But what are they? So that the appeal court can also benefit from that assessment. So that we can also appeal if we want to and say, no, these are not alternative remedies, whatever. But none, all we're told is that they are real and very real. That's all. Now, how could that be a judgment that decides on that point of alternative remedies, which doesn't say what alternative remedies there are, and therefore would not benefit any court? So that might be threadbare to Mr. I'm sorry.
Please listen. I was hoping not to interject in your argument today, but you really must read. Please, really must read the judgment. And don't misrepresent what's in the judgment. Go and read page 78, paragraph 122, 123, 124, 125.
Page?
Really, just read the judgment.
Page what? 78.
Yes.
Yes, but this is exactly the point. It's the same as what Mr. Breitenbach was such. I'll come to you about the proviso, to the legal refusal of legal representation. It doesn't, the court, of course, can say the respondents contended that and so on. And then the first respondent rebuffed this and so on. Counsel for the applicant said this, that's at 125. The very real alternative, likewise. But where does it say that what the court, not the respondent, the court, the court. What are the alternative remedies?
Mr. Mpofu, read paragraph 125. Counsel
Yes.
for the applicant, that's you.
Yes,
Dismiss the proposed-
counsel for the applicant dismissed the proposed alternative remedy as no more than illogical nonsense, but failed to persuade exactly how that was so. But that's not the test. The question I'm asking is not what counsel for the applicant did. What did this court find as alternative remedies? One,
Mr. Mpofu, please, why don't you listen for a change? The court made it quite clear that you failed to persuade exactly how that was so. Because you said it was illogical. Please listen. You said it was illogical and nonsensical. And the court then accepts. It accepts the alternative remedies put up by the respondents. What more must the court say?
it must say so. Where does the court say? But where does the court says it accepts those put by the respondent?
Mr. Mpofu, the judgment is as clear as crystal. If you don't read it, then you can deal with it elsewhere.
Yeah, well, my lord, if your lordship is saying in paragraph 125, which is where we are, there's a place that says the court accepts anything.
Yes,
Then,
read all this paragraph.
well, it's not there, I can assure you.
Yes.
All it says is that the applicant clearly has very real options, alternative remedies. And all I'm saying is that what are they?
Yes. Okay, good. You want to move on?
Okay, all right. So if and quite frankly, the alternative remedies, the discussion of alternative remedies cannot be reduced to the illogical and nonsensical. That was something said about one of the 5 remedies, and that was the issue about the suspension, the possible suspension. There were many. We spoke about the fact that you cannot use the very. Let me tell you what the alternatives that were actually presented. One of them was the fact that is the one that was presented just now, 20 minutes ago. The fact that you can have Part B as your alternative remedy. And we said that is not an alternative remedy. Then you'll never have alternative remedies. If you are going to say, you come to court and say, I'm here to assert a right, and then you are told, no, your alternative remedy is actually the one that you are going to get in Part B. I mean, what is that, really? What is that? So you must, that means interim relief should never be granted, because everybody will always have the Part B relief. Everyone who has Part A necessarily has Part B. So how can that be? And that's what is illogical. You cannot rely on the very relief that you seek in Part B to cure your interim harm, so to speak. That's why they say that for example, in defamation cases, the interim relief is only for future harm, but not for past harm.
Please listen.
Whereas,
please listen. You are re-arguing what you sought to argue a couple of months ago.
no,
You correctly earlier today said you're not here to persuade the court to change its position because the judgment is there. You don't have to re-argue the point. We've heard you. The judgment is there. So
no, I think you're misunderstanding me. The last thing I want to do is to persuade you that you are wrong.
please.
All I'm saying is that in this judgment, there is no place where you say what the alternative remedies are. That is a fact of life. It is not there, and that's all I'm saying. I'm not saying it was right or wrong or the court should change its mind. No, I'm simply saying it is not there at paragraph 125 as to what these very real options, yes, are. It's not there. In other words, maybe I would understand if your lordship was saying, maybe for the people who were involved in the case and so on. But if someone, all I'm saying is that if someone picks up this judgment, an innocent bystander, and reads that paragraph, they will not know what these real alternatives are. That's a simple statement of fact. Maybe because I was there, your lordship can say, but you were there, Mr. Mpo, written by saying this and that. that may well be so, but the test is not a counsel in this matter. The test is an innocent bystander or the appeal court wanting to discern what were the alternative remedies, and it will be left with nothing. Anyway, the same with the Mr. Breitenbach says that, how can I say that the court did not that the addition of the proviso was unexplained? And then you say, okay, then I wait for the next moment. Then he says, no, but it's explained in the speaker's affidavit at such and such a paragraph. But who cares? That's not the point. The point is, where is it explained in the judgment, not in the speaker's affidavit? Again, the test is not somebody who has read the ins and outs of Mr. Breitenbach's long affidavit. The test is whether it is explained in the judgment as to why there's a difference in the legal representation issue between a judge, between a president, and a head of a public institution. The answer is there is no explanation. I say that without any fear of contradiction. It is not there in the judgment. So there's no that explanation, except to say the respondent said this and this one said that. There's no judgment. There's nothing which says the legal representation is not desirable for such a person as a head of an institution because of A, B, C, D. It's not there. The point is simply not decided one way or the other. Not for me, not against me. It's just not dealt with. And so and then Mr. Breitenbach also says it's irrelevant. He actually says this with a straight face. It is irrelevant if the point we make about misinterpretation of Section 194. How on earth can that be irrelevant? How could it be irrelevant if Section 194 is interpreted incorrectly? The very section that is used to remove a person. And that goes to another conceptual difficulty, which is this question about, it also goes to this question about the review and the declarator. Because of course, if we were dealing with a review, if we were dealing with a review, then Mr. Breitenbach might have a point to say, look, insofar as you want to review this particular action, then you can only review that which affects you or the decision that is adversely affects you. But if once you understand that this is not, that point is not a review point, it's a point of constitutional invalidity, then it can never be irrelevant that the very statute that is being used against me is unconstitutional. How can it be irrelevant? You can say anything about it, but you can't say it's irrelevant. Then the issue about the incompatibility. Let me deal with this point before I forget. My learned friend says that this appointment of a judge to sit in the panel is, the words he uses, the sort of thing judges do every day. I mean, is it really? The sort of thing judges do every day is to be nominated by political parties. Not even in the Judicial Service Commission do political parties nominate judges, for obvious reasons. And here we have a provision of the rules that says judges must be appointed by political parties. And then we're told that's the sort of thing judges do every day. Well, not in this country. Judges do not get nominated by political parties. And what is wrong with that, if it needs repeating, is the fact that a judge that is appointed by a particular political party, and then the following parties? The 14. They say the 14 parties nominate 14 different judges. Then those judges, this one will be called, oh, that one is the DA judge. This one is the ACDP judge. This one is the EFF judge. This one is the one who was nominated by the ANC and so on. The following day, once the impeachment is over, that judge sits in judgment of another political party or of the one that nominated them. Then litigants are going to say, I mean, how can this person who was nominated by this very party play the role? That's what's wrong with having the judicial function not separated from a legislative function. It's not, it will, well, if this court thinks that's the sort of thing the courts do, judges do every day, all we can say is that another court might find that that's just, might just not be so. And then there's also a misalignment of what the interim relief in section 172 does. A learned friend says that the prayer for just and equitable remedy, which is 172 1B, is found in an unusual place, which is prayer number 8. Well, I don't know what that means. How can, it's in the notice of motion, in the prayers. That's not an unusual place, that's where it should be. The prayer for just and equitable remedy is where it belongs, in the notice of motion. That's not an unusual place. How can that be an unusual place? And just and equitable remedy is exactly the words that are taken from section 172. And that was put deliberately. It was not just sneaked in reply. It was put there up front on day one before anybody even did an answering affidavit or even a notice to oppose. It was there.
Mr. Mpofu? Mr. Mpofu?
Yes, madam.
Yes, let me raise something I found very interesting with regard to your relief.
Yes. Part A, my lord?
Yes.
Yes.
You see, in the applicant's founding affidavit, and also in your heads of argument that you filed initially, you set out the applicable regulatory framework. That's on page 46 of the record. Have you got it? It's under the subhead.
Yes, I've got it, my lord.
Yes. Can you see in the applicable regulatory framework, we go through it very carefully, and nowhere there do you ever raise the provisions of section 172 of the Constitution. Now,
yes.
That's the regulatory framework you raised with regard to the applicable legal principles. You then deal with the relevant case law, and there also don't deal with section. But what is most important also is that on page, these pages are not very clear, but in paragraph E of the founding affidavit of the applicant, she sets out the requirements for urgent interim interdict. And then she sets out prima facie right, irreparable harm, no alternative adequate remedy, and so forth and so forth. Now, what is very interesting is that there's a complete and absolute omission in the founding affidavit to deal with just and equitable relief. In fact, it's not dealt with in the founding affidavit. It's not dealt with in your initial heads of argument. For the very first time we see it is in your second attempt in your written heads of argument, which you submitted. And so when we look at the basis on which you seek to introduce the relief under section 172 sub B, it's quite clear, Mr. Mr. Mpofu, that was no more than an afterthought.
Well, it might be clear, but if you read then why did we rely on Amabungane, for example, which is on our heads?
Yes, but where
Amabungane, the whole point of Amabungane is that you must distinguish between an application for constitutional invalidity and one of review in the first place, and also the question of that the question of separation of powers does not arise in relation to an application for constitutional invalidity. This point about interpretation of Section 194, how on earth can that point be a review ground? Because it's interpretation, as Jafta says, and he's just being polite. He says he finds it difficult. He was just being polite to his colleagues. It was just judicial politeness. So he finds it difficult how an interpretation point of the Constitution can be said to have anything to do with this so-called separation of powers harm, for example. So I don't understand how, when we say there are, if you go to that relief, the one that you refer to, my lord, it's reduced at page 3 of your judgment.
Yes, no, we said it, we've read it. The point that we're making, Mr.
No, okay, can I finish my point at least? Yeah.
Yes, but I'm just pointing to you, we can go back there, we've read it. The point that is being made in the judgment and the point that is being made in argument is that the relief that you sought under Section 172(1)(b) was no more than an afterthought. And
so that
it's not consistent. It's not even the basis of anything raised by the applicant in the broad legislative framework in which the court the matter must be dealt with. It's not in your initial heads of argument. The first time we see it is in your replying documents.
No. Okay, so the afterthought came on day one when we were doing the notice of motion, because I've demonstrated that at paragraphs 8 and 4, if you look at paragraph 4 of part B, for example, that is on page 4, yes. We say again there, one, say declaring the removal to be unlawful, unconstitutional, invalid, void. Under what other section of the Constitution can that be except 172? Then we say, alternatively, declaring that the rules do not operate with retrospective effect against the applicant. Under which other section of the Constitution can that be except 172? Then we said paragraph 4, jump paragraph 3, because that's a review relief. Paragraph 4, such further alternative just and equitable relief as the court may deem appropriate. Where did I get those words if it was an afterthought? This was day one before anybody even knew the application was coming. So if the words just and equitable come from, maybe this court wanted us to say such further and alternative relief just and equitable in terms of section 172 of the Constitution. No, we don't have to say that. Once you use the word just and equitable, anybody knows where those words come from, at least should know. And then when you talk about declaring the rules to be unconstitutional, that's 172(1)(a). That very word, there can only be two options, either section 38 of the Constitution or section 172. There's nowhere else on the basis of which you can find something inconsistent with the Constitution that I know of. So as I say, if it was an afterthought, then it came on the very first day of drafting these papers. That's some afterthought. So the point is simply this: and also the other thing, my lord, that you must bear in mind is that the judgment of economic freedom fighters versus Godin, on which we also rely for this point, and we're grateful to the Constitutional Court, excuse me, was in the August 2020 report, and I think it came out in about April or May. That was long after the notice of motion was drafted. So one cannot even say, oh, now you saw the case of Godan and suddenly wanted to put just an equitable relief. That was done when we drafted this thing. It was in January, long before EFF Godan was even argued, I think. So the suggestion, the mere suggestion that reliance on 172, which is quoted, unfortunately, I didn't put the three letters 1, 7, and 2, but which is clear in the notice of motion that it was an afterthought. Well, again, I don't have to convince your lordship. All I can say is that another court might be able to know that the words just and equitable come from 172. Another court. No?
Mr. Mpofu, the court does in fact deal with just and equitable relief, but I don't see any challenge to the reasoning of the court in finding that it's just and equitable that the proceedings continue. There's no attack on that in your notice of appeal.
There is.
Where? Show us.
Everywhere. When we say, is it just and equitable? Is it, okay. So therefore, we're saying it's just and equitable that the speaker must appoint judges. Then we're saying it's just and equitable that the public protector must be denied legal representation. Then we're saying it's just and equitable that a new offense of temporary incapacity must be introduced. Then we're saying it's just, let alone equitable, that the heads of Chapter 9 institutions must be treated differently from judges. Then we're saying it's just and equitable that the public protector is not even given notice of charges against her. We're saying all that is just and equitable. Well, I can assure this court that we're not saying any such thing here, and we will not say it even in any other court, and in our papers, we do not say it, all those things are just and equitable. That she should not be given reasons for a decision on prima facie. How can all that be just and equitable on any reading of what we're saying in our founding affidavit, in our heads, and even in this note that we just gave you this morning? Anyway, so in case there's any ambiguity, we say all those things are not just and equitable relief. And we're saying that particularly the misinterpretation of Section 194 by the legislature, the National Assembly, is not just and equitable, to say the least. So what this court said, and I can't explain this any further than to say that the review grounds, the issue about the review grounds, the three review grounds, which we concede, as far as the three review grounds are concerned, the outer test can be applied. But as far as the Section 172 grounds, the remainder of the grounds are concerned, as Chapter J said, outer is not applicable to that. It can be clearer than that. It's simply not. And if another court might also find the same, that outer is not applicable to the 7 remaining grounds based on 172. This court found that it is, that's fine. That's par for the course. But another court might find that all the other grounds that are based on the declarator rather than the review are not susceptible to the outer test. As I say, Chapter J may be wrong, but he may be right. That's all this court just has to accept now, for now, that another court might agree with him or not. But at least there's a rather reasonable probability that it might. Now, lastly, Yes. Yeah, no, it's fine. There is a difference between the outer test that says you must avoid the review grounds, such as we are dealing, insofar as we are dealing with review grounds, and the other test that says it is required that you must pick into them. Because so that's a completely different things. 67.
Mr. McPherson,
I'm sorry.
you are busy replying. You are not arguing afresh. You are repeating yourself. It is 6:10 already. Please, can you try and wrap up?
Well, Mr. Bartlander raised this point about avoidance versus. So am I not allowed to reply to that?
If you can reply shortly, that
Yes.
is in order.
Oh, shortly. Oh, yes. Thank you. So the part that this court, as I say again, said it does not discern any difference between Godan and outer. That's fine, but the court must just accept that someone else might discern that difference, which is at paragraph 67. It says that. I'm sorry, I think it's 42. Yes, it's paragraph 42 of Godan. It says, and this only applies to reviews, by the way. But in addition, before the court may grant intermediate, it must be certified that applicant for interdicts has good prospects of success in the main review, not in the main declarator. The claim for review, again, must be based on strong grounds which are likely to succeed. This requires the court adjudicating the interdict application to pick into the grounds of review raised in the main review application and assess their strength. So 2 points. One, this is about review and the main review. But secondly, the court is required, as opposed to avoiding which Mr. Negati CJ said. Now again, that difference between the two cases may or may not be discernible now, but all we're arguing is that it will certainly be discernible to the Constitutional Court because it was the Constitutional Court by Hampepe ADCJ for the majority that said the words that I've just read. So certainly the Constitutional Court, at least, I don't know about the SCA, but the Constitutional Court may just agree with itself that the court is required to pick into the grounds, as opposed to or they might show that there's a nuanced difference between the two things. Avoidance on the one hand, and a requirement to actually do something. Avoiding means not doing something, and then required to do something is the exact opposite of that.
Mr. Mpofu, you did say lastly, before you made that point.
Okay, Laura, we can't go through this again. I'm just looking through my notes.
No, we can't go through it again. I agree with you.
Well, I'm just saying I'm not going to stop mid-sentence again. Yeah, so I'm just looking through my notes to see. Yes, okay, the last point is, which is part of the one that I just raised, that the test, going back to the base, these parties here, my lord, have disagreed on almost everything. But there's one thing that they agree on, which is that this case is of serious public importance, that it raises novel matters, and that these are issues. It's the first time that there's going to be any impeachment of anybody, quite frankly. So in terms of 17(1)(b) 182, which is, I don't have to take the court there, but other compelling reasons. The word other means other than the prospects of success. So even on that basis alone, the court should, I would imagine, accept that other courts need to pronounce themselves on such an important issue.
Mr. Mpofu, you've now said that all the other parties agree that this raises novel issues. They agree that Part B raises novel issues, not Part A.
No.
Please read the heads of argument, because it's as clear as crystal. They say Part B raises interesting and novel issues. Part A does. Part A simply deals with interim relief, and there's nothing new and novel about that. So don't misrepresent what the other parties are saying.
Okay, forget about the other parties. I'm saying that, yes, yes, okay. I'm saying that the question as to whether a functionary such as a public protector who holds a personalized position in terms of section 181 and 182. In other words, it's I don't know how to describe it. It's like the office of the Chief Justice. It resides in a person. An office like that, for it to be deprived of that person because the person is undergoing disciplinary steps, is unprecedented, is weighty, and if we know the name public protector, is obviously of importance to the public. Quite apart from the fact that the only case that refers to these issues is the case of the EFF versus impeachment, which is a constitutional court decision. That's the only, these rules, by the way, were only drafted because that case was handed down by the Constitutional Court in relation to Section 89. Otherwise, these rules would not be there. So it's important, even in that sense, that the only authority is Constitutional Court authority. And it may well be that the question of what should happen in the interim is, which was found in many cases, including EFF versus Godan, to be per se harmful to the holder of an office. Okay, in that case, it was a minister. Is itself something of quite grave importance. Even if one were to do the nitpicking of saying, well, only Part B is of novel importance, but Part A of Part B is not. Well, maybe that may well be so. But this Part A doesn't float in the air. It's Part A of the novel and very important issues that are raised in Part B. Actually, it's the same case. It's the same application. It cannot be artificially, unsymbiotized, if you like. You can't take the one part of that case and say it's important and novel, but the other one is just old and unimportant. As it pleases. So anyway, and then that section 17(1)(c) is addressed in the heads. I'm not going to go into it. In my respectful submission, on the basis of section 17(1)(a) alone, Roman 1, before we even go to compellable reasons and all that, and whether it's a novel or not novel, is sufficient on the facts of this case, and particularly given the deficiencies in the judgment and the non-adherence to the Mpahlele standard of of adjudicating the issues. Anything else? As a court, please.
Thank you, Mr. Mpofu, and to all the other counsel who've been part of the hearing this afternoon. Thank you very much for your argument and your heads of argument in this matter. Judgment on the application for leave to appeal is reserved. And thank you, my colleagues also.
Yes, thank you very much.
Miller. And so that's all from our side. Thank you and goodbye, everybody.
Thank you.
Thank you.
Thank you.